A few minutes ago, three-judge bench of the High Court has delivered, led by Honorable Mr. Justice Nga, Honorable Mr. Justice Mugambi, and Senior Counsel Chigiti, Honorable Judge, have delivered a judgment in which the petitioners, who are members and supporters of the Jubilee Party, had filed a petition stating that in the year 2023, the governor of Isiolo and his deputy defected from Jubilee Party to UDA during a public functions held in Isiolo. In the course of their judgments, the judges underscored the fact that Kenya is a multi-party democracy in which all elected officials are required to remain loyal, to keep fidelity to the parties that sponsored their elections. And the only way that somebody could change their political affiliation is through the specific provisions set out in the Political Parties Act. And they have also added that it is the responsibility of the High Court to ensure that multi-party democracy, being the linchpin of Kenya's constitutional order under the 2010 Constitution, is protected. This decision is absolutely important because in the recent times, an impression has been created that multi-party democracy is not a matter of law, but a matter of political convenience and choices by the members of the political parties and the political class. So we go home with that, the fact that the High Court has underscored the primacy of multi-party democracy in Kenya, and that it will and shall be protected by the courts of Kenya. And it is also important that they disagreed with an earlier decisions of the High Court, where the High Court, in the case of Obado, the Migori governor, the High Court had expressed itself to say that it is not mandatory for a governor and the deputy to cease being in office on account of changing their political affiliation. They have said that under the Constitution, governors, like members of parliament and MCAs, must remain loyal to their political parties to the end, unless such affiliation, political affiliation, is changed in accordance with the law. Turning now to the narrow issue on whether or not there was sufficient proof that there was defection by the governor of Isiolo and the governor and the deputy governor. They have said that sufficient proof was not given, that dates were provided, but the specifics and the evidence that such defection occurred was not provided. I think as counsel for the petitioners, I admit that one was lacking. I believe we were doing two similar cases at a particular time, so there was an oversight in filing an affidavit that ought to have provided that evidence. So the governor of Isiolo, on account of that oversight, has gotten away with some illegality. But since we are too close to the elections, I do not think that much purpose would be served with an appeal or presenting that evidence to the Court of Appeal. I think moving forward, the people of Kenya will have to make these decisions in a manner that protects the Constitution of Kenya. So I believe, speaking for the petitioners and Azimio Party, is a good decision. We shall definitely make use of this decision very soon, because we have seen the kind of unlawful governments, like these broad-based governments that have been created, in which the opposition and government have merged in parliament. So these decisions will be put to better use very soon in this matter.